A start, please. My name's Christopher Warren, and with me is David Liddell. We're Scottish Government reporters. So we'll just pause there. Sorry, again, Conor or Craig, I've just got feedback of what I've said in the room. Sorry, everyone, just bear with us a couple of moments whilst we just sort out a few issues. Frozen again. I will try again. Could people just give me a quick thumbs up if you can hear me clearly, please? That looks promising. Okay, we will give it a go. Apologies, everyone. So I shall start again. My name's Christopher Warren, and with me is David Liddell. So we're Scottish Government reporters, and we've been jointly appointed to hold a public inquiry into the application made under Section 37 of the Electricity Act 1989. It's for the proposed Kintore to Tealing 400 kilovolt overhead line connection. And the need for the inquiry follows an objection to the application made by Angus Council. And the inquiry will consider the whole line, whilst noting that Aberdeenshire Council does not object to the scheme. After the inquiry, we'll report back to the Scottish ministers, and this will include our recommendation on whether or not consent should be granted. Now, the purpose of today's meeting is solely to discuss procedural arrangements for the inquiry. That's as set out in the agenda. Now, everybody in the meeting today should have received the agenda from us. It is available on the website too, if any observers would like to see it. The case reference is TRL-120-1. So for the avoidance of any doubt, there'll be no discussion about the merits of the case today. So before I go any further, I'd like to just double check that everybody can hear me clearly still. So a thumbs up or down will suffice again. Great. Please do tell us if that changes. I've noticed our camera has frozen a couple of times. Please tell me if you notice that. I can refresh it. That should sort that out. Now, there are some basic housekeeping points to mention too. And these will be important given how many of us are on the call today. So please, if possible, could I ask everybody to keep cameras turned on? It just means we can see that you are kind of present and everything's working from your side. But please keep your microphone muted unless you're speaking. Now, if you have a question or if you wish to speak at any point, please raise your virtual hand, and you can find that in the top bar of the Teams application. Failing that, again, keeping your camera on means you can give us a wave. So if we miss you, please do that and we will try and spot you. Now, depending on progress, we may take a break at a convenient point this morning. We don't expect this meeting to run beyond 1 p.m, so it's unlikely that we'll break for lunch. The meeting's being live streamed on the DPA's YouTube channel, and a recording will also be available after the meeting on YouTube. So by participating today, you are consenting to being filmed and to the recording, storage and use of the material for webcasting. It's used for training too and for the keeping of records that are accessible to the public. We'll be making a note of our discussions this morning, and we intend to circulate this within 7 days. And this will set out all the final procedural arrangements that we discussed today. We'll try and progress reasonably swiftly through the agenda this morning. Generally speaking, we'll pause only to debate any areas of disagreement. However, there is quite a lot of ground to cover, so please do bear with us. In a moment, we'll ask you to introduce yourselves. We should just note, as you're aware, that we've limited who was able to join this meeting. Now, that's partly because the nature of a pre-inquiry meeting is that it is actually of limited use to many individuals. The reason was largely, as you know, I think, because of the significant number of interested parties. So as it stands, we have around 230 opted-in parties. Realistically, we couldn't manage this meeting with any more than a fraction of that figure. So you've been invited today on behalf of opted-in representative groups, so you're able to represent the majority of interests. It's important that I reassure everyone that where we have an inquiry or hearing session, those who have previously made a representation and have since opted into this process will be able to take part in an appropriate session, as long as they confirm their participation after this meeting, but we'll come back to that. So for introductions, we will start with the applicants, please.
Good morning, sirs. I'm Alistair Burnett, King's Counsel. I'm instructed with Junior Counsel Graham Middleton by Geraint Hughes of the legal department of the applicant, and I'm in a room with him and another couple of members of the project team, but the intention is that I will be the person speaking on behalf of the applicant at this meeting.
Thank you. And for Angus Counsel, please.
Morning, sir. My name's James Finley, King's Counsel. I'm appearing with Ewan Brown, and we're both instructed by Tina Kidd from Angus Counsel.
Thank you. Good morning. For Aberdeenshire Council, please.
Good morning, sir. My name is Rob McIntosh. I'm Principal Solicitor at Aberdeenshire Council, and today I'm accompanied by my colleagues Elizabeth Tully, Senior Planner, and Stephanie William, Planner.
Thank you. Good morning. For NFU Scotland.
Good morning, Rhiannon Montgomery. I'm the Rural Business Policy Manager on behalf of NFU Scotland.
Good morning. For Banchory Community Council.
Good morning. My name's Sue Patterson and I'm representing Banchory Community Council.
Morning. And for Trethys, Drummock and Durris Community Council, please.
Good morning, I'm Anne Shearer and I'm representing Trethys, Drummock and Durris Community Council.
Good morning. For Ecton Skene Community Council.
Sorry, good morning. I'm Fiona Bick. Representing Ecton Skene Community Council.
Thank you. For Fewside Community Council, please. Inveresk Community Council. I thought
there is.
Oh, did I? Sorry, is that me?
Hi,
Marston. Inverness Community Council.
Yeah, hi there.
Hi there.
For Kintore District Community Council.
Hi, June Morrison for Kintore District Community Council.
Good morning. For Kirriemuir Landward East Community Council.
I am John Grieve from Kirriemuir Landward East.
Good morning. Newlands Community Council.
Good morning. My name is Kate Matthews and I'm representing Mearns Community Council.
Thank you. And for Tealing Community Council, please.
Good morning, Steve McSwiggan representing Tealing Community Council.
Thank you. So I don't have any other community councils on our list. Are there any others on the call that we're expecting to be participating? Okay, that's reassuring. Then we have the objection groups. So coming to no teacup first, Mr. Campbell.
Good morning, sir. I'm John Campbell. I'm representing No Teacup Limited, an amalgamation of anti-Powerland groups. I have certain colleagues with me here in the room.
Okay, thank you. For Save Our Mearns.
Again, Kate Matthews, also representing Save Our Mearns.
Thank you. And then from Galbraith. It's Mr. Thornton Kemsley, I believe. Yeah.
Yes, I am representing various landowners affected by the route.
Good morning, right, thank you. Have we missed anybody at all? Is there anybody else on the call who was expecting to be participating? Okay, thank you. So an important point to make just before we move on is that as we go through the agenda today, we may be asking if there is scope and merit in more than one party grouping together in making the case on particular topics or issues. So please just be mindful of that. So once we begin to discuss the type of procedures that will follow for the inquiry, appreciate decisions on that type of thing are unlikely to be made today, but it's just something to keep in mind, please. So we'll move swiftly on to item 2 on the agenda. Now, the application is one of several priority applications for strategic transmission infrastructure. In February 2025, the Scottish Government produced guidance for priority applications and how they'll be processed. Now, we plan to follow the key stages in the process set out in that guidance, and there's a hyperlink to this document in the agenda. That said, there are no detailed procedural rules for the conduct of inquiries under the Electricity Act. EPA has, though, produced a code of practice which has been modelled on the 2013 planning appeals regulations, and we expect to broadly apply the code of practice in this case where it's relevant. And there's a link to this in the agenda too. Essentially, the code allows for flexible procedures. So each issue that requires further procedure will be dealt with by the most appropriate method of examination. So this could be an inquiry session, a hearing session, or further written submissions. And the aim is for any further procedure to be efficient and proportionate. And on many issues, sufficient information will already have been submitted. And where that's the case, we will not be using any further procedures. It is important to recognise that when we write our report to Scottish ministers, we will be taking into account all of the environmental information submitted by the applicant, together with all the consultation responses and any letters of representation already lodged, as well as evidence gathered through the inquiry process. So it is really important to stress that the type of procedure being followed, or indeed the absence of any further procedure, should not be interpreted as a judgment on the relative importance of one topic over another, or the weight that may be given to them. It simply means that for some matters, we may have enough information on that subject to be able to draw our conclusions. Now, at this point, we want to take the opportunity to briefly explain the different procedures that can be used as part of an inquiry. For those of you in particular who haven't been involved in anything like this before, I think so. I'll draw breath and I'll hand over to Mr. Liddle to take you through the various kind of options that we use.
Okay, thanks, and good morning, everyone. Okay, so yes, I'll just set out what we mean by the different types of procedures that we could adopt. For those of you who've maybe not done an inquiry before. So for what we call inquiry sessions, each party would be invited to present evidence from a witness, reading from a written statement, which is known as a precognition. And the witness would then be subject to cross-examination by those of opposing view. So for objectors, for example, in this case, that would be cross-examination by Mr. Armstrong. Sorry, Mr. Burnett. And usually, parties are legally represented and lawyers do the cross-examination or question the witness, although it's not essential to have a lawyer. And we as reporters might also have some questions. Now, inquiry sessions are more formal than hearing sessions and are particularly suited to topics where there's a lot of technical evidence. Written material will be required in advance, which states your case, including an inquiry statement and the precognition, which I referred to. And we would likely webcast those sessions. Hearing sessions, instead, take the form of structured discussion between the parties involved, which one or both of us would lead. There would be no formal reading of evidence or cross-examination, and we would prepare an agenda for each hearing session in advance. There's no need for legal representation, again, although parties' lawyers can take part in the discussion, and indeed they usually do if a party is represented. Hearings are generally more informal than inquiry sessions in comparison. In advance of a hearing session, all the participants would be expected to prepare a hearing statement, setting out the scope of their evidence. Again, we would likely webcast those sessions. Community hearings differ slightly to more conventional hearing sessions, and this will be a type of hearing focused solely on hearing and understanding the views of local residents and organisations, and allowing parties to make brief presentations based on their previous representations, ideally grouping together those with similar interests. And we might seek points of clarification from those presenting and from the applicant if necessary. But normally we would be there primarily to listen to rather than to challenge or to delve deeper. The advantage of these sessions is that any matters can be raised, so it avoids a need for individuals to be involved in more technical sessions on a particular topic, where contributing to that may be more difficult or for some people more intimidating. It also allows matters to be raised where no dedicated sessions on that topic are taking place. Now, these sessions probably wouldn't be webcast, and we would intend to hold a series of these in local community venues, probably in the afternoon and or evening. We'll come back to discuss it. So for local people wanting to participate, we do feel these sessions are probably the most accessible and the easiest way for most people to participate in inquiry. But we'll come back to that. And finally, for me at this point, site visits are also part of this gathering process. We've already made initial site inspections for the entire length of the proposed line for a 2-day period last week, but we envisage a need for further specific site inspections, potentially including some people's homes. And we've noted a number of requests from people already that we do this. So I'll hand back to Mr. Warren for now.
Thank you. Okay, so looking back to the detail of lots of what Mr. Liddell's outlined there. So I intend to move on to agenda item 3 because we can come back and discuss kind of detail, as I say. So moving on to item 3, you'll see in the agenda and its appendix 1 that we have already set out our initial thinking on how we believe the place should proceed. And we will discuss the detail in a moment. I know that some parties are seeking further procedures on various other subjects, and we will come back to that too. So don't worry if you think that you're missing your opportunity to cover that. We will come back to it. So if we can turn to Appendix 1, you'll see we're proposing to hold community hearings in the first of 2 weeks. That's the week beginning the 15th of June. We would envisage that these would be where most participants and certainly individual members of the public would potentially be involved, rather than the more technical sessions proposed in week 2. That'll be the week beginning the 22nd of June. Regarding in terms of kind of topic specific matters, so firstly looking at agricultural operations. Now, Mr. Campbell and Mr. Thornton Kemsley, you amongst others have raised the matter of whether the development's operational effects on agriculture and associated matters of safety ought to have been scoped into the environmental impact assessment. Now, we have the applicant's response to this through the kind of the procedural points that have been raised ahead of this meeting. And we received that on the 13th of March. Mr. Thornton Kemsley, we have your comments too on that response, which we received on Monday this week. So we've seen all of those. Now, our view at this stage is that further written submissions at the outset would help us to more fully understand the precise nature of the concerns here and the extent to which this might result in significant environmental effects. So we're not ruling out the need for further oral procedure at this stage, and a hearing may be necessary. You'll see that we have actually scheduled one in for the beginning of the second week of the inquiry. I should just say as well, at this stage, we're certainly not ruling out the possibility of requesting additional environmental information on this matter, but we want to get responses first in writing and take it from there. Is there anything that anybody would like to add on that particular point now? Mr. Campbell, please.
Good morning, sir, and thank you. I'm sure Mr. Thornton-Kemsley will want to add to what I have to say, but our fairly strong view in relation to this topic is that it should be the subject of an inquiry session, importing into your examination, as it does, quite a large number of highly technical questions, not only in relation to the conduct of agriculture, but also to questions of health and safety involving large-scale agricultural machinery. Now, I don't want to repeat what Mr. Thornton-Kemsley has said, because he can speak for himself, but I would want to observe that we find the applicant's response to the initial Galbraith letter to be manifestly lacking in content, which is very disappointing, because the issues are serious ones involving not only the effect on agricultural operators, but also potentially quite major health and safety issues. So I think, want to just close just now by saying this is a major topic. It should have priority. If Mr. Thornton-Kemsley is right, then it bears not only on the design of the line, but also on its landscape and visual impact, as well as on agriculture and health and safety. So I would ask you to give it that level of importance in your deliberations. I'm not able to see, but no doubt you'll enlighten me, what further written submissions would bring to this discussion. It's a matter for oral evidence. The oral evidence is prepared, at least on this side of the argument, and we're ready to go with it, subject to your timetable. I hope that's on it.
Thank you, Mr. Campbell. Yeah, that's helpful. If I can come to Mr. Thornton-Kemsley next, please, if there's anything you'd like to add.
Well, sirs, 4 points to make, and I'll try and make them as briefly as I can. But this is a major concern to my clients and the agricultural industry. The applicant in Volume 2, Chapter 7, Paragraph 7.
Mr. Thornton-Kemsley, you've become muted somehow.
That's it. That's it.
Yes. Thank you.
Thank you. The applicant has made no assessment of the impact on agricultural operations after construction. These have been scoped out in Volume 5, Appendix 6.1, Paragraph 464, where it says it is not predicted that there would be significant adverse effects on agricultural use as a result of the proposed development, and these effects are therefore proposed to be scoped out. The reporters will be aware from representation from National Farming Union, from the Aberdeenshire Council and some community councils, that this is a matter they too consider should be addressed. It's somewhat surprising that for a project crossing some of the best agricultural land in Scotland, that the applicant continues to scope out the main environmental factor given the circumstances. SSEN have scoped out agriculture in other overhead line projects. They didn't do so for Bewley Denny, and other regional electricity companies do not appear to have scoped out agriculture and health and safety in other CP 2030 projects in England. You'll have read the socio economic impact report appended to the application, that doesn't address the number or financial impact on capital properties, on capital values to properties where there's no right to compensation. And nor does it address the impacts from the loss of POW, other than to record that agriculture, forestry and fishing represent 5.1% of the employment market. SSEN are telling farmers to remove polytunnels from the route. Despite being aware from consultations that affected parties of the importance of the seed potato industry and the potential for this project to become a super spreader event for potato cyst nematode and clubroot, two of the main soil pathogens affecting crops in this area. The potato industry, if some of you were awake early enough, was reported on Farming Today to be worth £100 million per annum to the Scottish economy. That is under threat from this project. These topics have not been addressed, nor is the potential use of technology already in use in agriculture, such as drones and the GPS systems. Nor has the applicant addressed future technology, such as the use of autonomous vehicles, despite being aware of such issues from consultations on alternative routes in this project. My second point, sir, is that what they are asking us to do is modify our existing farming practice. And you can see that from an email from SSEN dated the 6th November 2024 from SSEN's head of projects, which I suspect you may have seen. This acknowledges that it is not likely that all types of high agricultural machinery will be accommodated. The impact of the clearances planned mean that combines cannot be used under 148 hectares of prime agricultural land. That's 2,871% more than the 4.98 hectares set out in the Section 37 application.
Mr. Thornton-Kemsley, sorry to interrupt you mid-flow. I'm just mindful of the
I understand
kind of boundaries of this meeting in terms of being procedural, and we are starting to stray into kind of planning merits. In terms of the procedures that I outlined at the start of this agenda item, in terms of our intention to ask for further written submissions to lead us into potential kind of further procedure, could I have your view on that point specifically, please?
I think that you should be scoping back in agriculture and health and safety. That is the only way that you will have all the information in front of you in order to decide the Section 37 application.
Thank you. I would like to give the applicant an opportunity to comment on what they've heard. But first, can I just check, Ms. Montgomery? Could I just ask you if there's anything that you'd like to add on NFU Scotland's behalf?
Thank you. Yes, I would just agree with what has already been discussed. I think that, yes, scoping it back in is the only way to see the true impacts, and I would encourage for a full inquiry rather than just written evidence, although we are happy to submit further written evidence if that is required.
Thank you. Mr. Bennett, if I could come to you, please. Is there anything that you would like to say in response to what you've heard, and particularly focusing around what may be appropriate further procedure?
Thank you, sir. I don't intend to get into the merits of the matter. As has been indicated, the applicant has followed what is fairly standard procedure in its EIA so far, and the issues that are being raised here are being raised and perhaps novel or certainly more vociferous than previously. And in light of that, the applicant accepts that you may well require further consideration of this topic. but we would be content in first instance if this were done by the way of further written submissions, at least to identify more clearly what the objectors are basing their objection on. And I know that Mr. Campbell says he's already got a number of oral evidence type documents prepared, and if they are in the sort of form that could be disclosed to the inquiry, that would be helpful as part of an initial exchange of written submissions. And then I think you're correct that after you see that, you may be in a better position as to decide whether you require a hearing session in addition to that as well. But I don't think it's a matter that requires a full inquiry session, but it is very much a matter for you, sirs, what information you think you need to be able to consider this topic in order to make your recommendations. But as I say, I think it would be sensible to have, in the first instance, a further exchange of written submissions, and with the possibility thereafter of organising a hearing session.
Thank you, Mr. Burnett. So you appreciate there's two of us. We would want to discuss this in more detail before confirming how we wish to proceed. We don't intend to do that whilst you kind of look on, but certainly I think our intention will be leaning heavily towards the further written submissions in the first instance, to be able to just understand positions as clearly as possible. And I think from then we are likely to kind of form our view as to what further oral procedure, if necessary, is going to be required, and or whether further environmental information is going to be needed. So it's very much, I think at this stage everything is kind of potentially on the table, but we will confirm our questions in the note of this meeting in terms of further written submissions. Okay, so I intend to move us on now so again referring to Appendix 1. So for landscape and visual effects, we'd originally envisaged, as you'll have seen, a inquiry session, although we've noted that both the applicant and Angus Council have indicated that they would be content with, or perhaps actually prefer a hearing session for this topic. So I'd like to ask, I'll come to you, Mr. Finlay, first, and then Mr. Burnett, just to for your views on why you consider that to be the more appropriate route, please. So, Mr. Finlay.
Well, thank you, sir. Yes, we have two main reasons. Firstly, that there are a number the landscape and visual information is fairly fully set out. We have a report from Carol Anderson that you will have seen. In our experience, dealing both with overhead lines and indeed wind farm applications, it is better to have a hearing session, because then you can, if you have a particular issue, you can hear from both sides on the same viewpoint or the same landscape character type, the impact on that, rather than having it by way of cross-examination. So you have all one thing first and then the other. It usually comes down to differences in professional judgment, and it's between parties. And unless there are distinct methodological issues dividing them, it's rarely in our submission useful to have cross-examination of such differences of professional view. It's more that you should understand them fully, which you can do by asking relevant questions and hearing them, and then forming your own view from site visits you've already undertaken or otherwise. Secondly, our preference is to use Carol Anderson as our witness, and she is only making herself available for hearing sessions. We do have an alternative witness if it is an inquiry, but our preference would be to use Carol Anderson. So in our submission, it would be more beneficial to you, or should be, given the witnesses are intended to be present, to have a hearing session.
Thank you. I think it's correct to say that we have conducted hearings and inquiries for landscape and visual effects sessions previously. In this case, do you see, Mr. Finlay, any disadvantage of not having an inquiry session out of interest?
We don't see any disadvantage in not having an inquiry session. Sometimes quite often it's the applicant for a particular proposal that insists on an inquiry session. Quite often that's the case, or seeks to insist in wind farm applications. Certainly in my experience, there is no disadvantage in proceeding by way of hearing as opposed to an inquiry, but potentially significant advantages.
Thank you. Mr. Burnett.
Thank you, sir. Yes, I'm in general agreement. There's obviously a requirement for an oral session of some sort in relation to this topic. And as Mr. Finlay says, in this particular instance, there doesn't appear to be any particular technical disagreement between the experts on behalf of the council and on behalf of the applicants in terms of methodology, and indeed a degree of agreement about the effects as well. And in that situation, it may be more beneficial for you, sirs, to be in charge of asking the questions and having the two witnesses answer effectively the same questions about the same viewpoints at the same time, and to answer the questions you have, rather than all the cross-examination that might or might not be helpful to you. But we're reasonably neutral, but with a slight preference, because the council has requested it for a hearing session in relation to this issue, given the restrictions they have in relation to their expert witness. But we're happy either way, but with a slight preference for the hearing session. And I don't see any particular downside to that in this instance.
Thank you. That's helpful. Mr. Campbell.
So thank you. As you would understand readily, this is a topic which features in many objections and has exercised a large number of people. I'm in agreement with Mr. Finlay's analysis, and that there should be a hearing session or two on this topic. No TKAUP has engaged a landscape architect for that purpose, and her work will be made available, of course, to the inquiry in whatever form it takes. But broadly, a hearing is what we're after.
Thank you, Mr. Campbell. And going, and as a complete aside there, Mr. Campbell, I noted that you referred to yourself as no TKUP. Would you prefer that to no teacup? I should probably get this right at the start.
That's very kind of you. No teacup is fine.
Okay, thank you. Okay, well, thank you. Are there any other views that anybody would like to express before we move on? Okay, so we will, Mr. Liddell and I will discuss this after the session, and we'll confirm in the notes of the meeting the decision. We can hear the views very clearly there about preferences. So we will be taking that into account in our final decisions there. Okay, so moving on to the next kind of hearing session that we're proposing, and that's relating to conditions. Now, I should just make clear at the outset, we must provide ministers with a list of conditions for in the event that consent is granted. But this won't prejudice our findings or recommendation. Now, we'd envisage that the applicant and both councils can reach agreement on most matters before any session. Some careful thought will need to be given to how conditions would operate in practice, and particularly how conditions are deemed planning permission would be discharged, given the proposal spans two planning authority areas. So that's something we need to be alert to. So in advance of that session, we'd like a schedule of conditions highlighting any matters of outstanding kind of disagreement, and that would be required by the hearing statement deadline. It's probably worth me noting as well now that Historic Environments Scotland wishes to be involved in the drafting of conditions that are relevant to its interests. The same might be true for other consultees. Now, we'd envisage the conditions hearing would be an appropriate section to explore whether Angus Council's objections to the scheme relating to biodiversity enhancement and loss of ancient woodland and the the question of compensatory woodland planting may be addressed. But I'd like to hear views on what I've just outlined there in terms of a approach to conditions and capturing the points around biodiversity enhancement in particular. If I can come to Mr. Finlay first, just to get council's position on that, please.
Well, so I'm grateful. In essence, the council wouldn't provided, let me start again, provided the council can raise the issues about its reasons for objection 2 and 3 and the policy issues that lie behind them, whether that's done in a conditions session or a standalone session matters not. The real point from the council, and we've touched on this in correspondence, is that because the council's objection was against officer recommendation, there isn't a fully articulated view as to how those how the 3 reasons taken together should justify a reason for refusal. And we have an appropriate planning witness who can articulate that, provided we're given the opportunity to articulate that in either by written representations, or our preference would be at a hearing session, then we're content with that, whether that's part of a condition session or a standalone session.
Okay, thank you. Mr. McIntosh, I appreciate that the Leadership Council has indicated it would confine itself to the conditions session. Could I have any views that you would like to have, please?
Yes, although we maintained a non-objection position, given the impact on the operating, we would seek to be involved in any conditions sessions and input into any drafting those conditions, working alongside Angus Council and the appellant to, as much as possible, come to an agreed position.
Thanks for your patience.
Thank you, sir. You'll understand that there's quite a significant degree of sophisticated knowledge amongst the communities along this line, and the content of conditions will be of very real interest to many people. There has been a bit of a tendency in the past, I regret to say, to circulating conditions, draft conditions list amongst the official bodies, the councils and the applicant, Historic Scotland, Nature Scot, and so on, and remembering the third parties only at the very end of the line. Now, we're not bargain basement participants in this case. We have a significant number of things to talk about. So could I ask those who are responsible for drafting the conditions, please, to remember to include me in that circulation and not leave it until the last week.
Thank you, Mr. Campbell. I'm sure that's been noted by others as well as by us. Mr. Thornton Kemsley, please.
Yes, sir.
I would just like to point out
sorry to interrupt again, Mr. Thornton Kemsley. We've got a very strong echo. I don't know if others are picking it up too. Do you possibly have 2 devices turned on with the sound or anything like that?
No, I think we've dealt with it.
We're still getting it. I wonder whether, Mr. Campbell, I can see you're not muted. I wonder whether if everyone else can just ensure they're muted and might solve the problem.
Right, Mr. Thornton Kemsley. Come on, try again.
the concerns of my clients.
Yeah, we are getting an echo. I think if there's nothing that, so if nobody else has got audio on in your office space there, Mr. Thornton Kemsley, then I think just we will try and capture what you're saying, albeit with an echo.
My apologies. The concern of our clients is with regard to the safe operation of agricultural machinery under the line. Now, the applicant has this limit of deviation, vertical limit of deviation, and in its correspondence in March 25, it stated that raising clearances to assist farm operations is not specifically required to meet minimum safety clearances. Therefore, here to be acknowledging that increasing clearance heights is an option, and that within the application there's a vertical limit of deviation of 15%, 9 meters, in respect of individual pylons. But at present, I cannot see that you have sufficient information to decide if such a variation is necessary. And you certainly don't have information on the additional steel and potential changes to visual impact that could follow. Therefore, my clients are concerned with regard to any or the imposing of conditions, because at the moment, SSEN appear to delegate safe operation of the overhead line on our clients. So that's the point that I would like you to take into account.
Thank you. I'm pleased to say the echo disappeared after about 5 seconds there, so we caught all of that, so thank you. Ms. Bick, please.
Yes, thank you. I would just like to echo John Campbell's point about the conditions and consideration of the conditions. Having been involved in a recent public inquiry on another application, I do feel that the community councils will also want to be updated or kept informed at a much earlier stage in the proceedings about any so-called agreed conditions between the local authority and the applicant.
Thank you. I think we can build in. I think we can build in sufficient clarity about what we expect in terms of exchanges to kind of reassure you on that point. So we've noted that, and we will think about how we can ensure that's captured properly. Mr. Grieve.
It's really just to rather reinforce the point there from Fiona, but also to I'm slightly concerned that there's a bit of a twin track approach appearing here between experts and community, expert perspectives and community perspectives, and I really want to be sure that we're going to achieve a balance here. I know you're technically very well qualified to ensure that we deliver this, but all the conversation thus far has been around specialist issues, technical issues, and the community issues tend to be more inclusive, more representative of the varying aspects that affect all different aspects of the community. And I know as a community council, we have had extreme difficulty in getting our voice heard or our representations across or even acknowledged. And really, I think I just want to raise a hand and stress the need to ensure that as we go ahead.
Thank you, Mr. Grieve. I think that's a very fair point and something we're very conscious and mindful of. I think there is always a challenging balance to strike in between kind of technical sessions, which could sometimes be quite inaccessible for members of the public, and then community sessions which take a different format. There is a balance to strike. We are scheduling 3 community hearing sessions because we want to hear what everybody wants to say, and to offer that in a manner which is more accessible than the other sessions in the second week may be. But that doesn't close the door for others to participate in those more technical sessions if they wish. I should just make that clear. Okay. Mr. Burnett, is there anything else that you would like to add or comment on before we move on?
Not really, sir. I think both the applicant and the councils are well aware of the need to cooperate in relation to proposing draft conditions and making our positions clear. And I think the ECU have already provided a standard set of conditions as a starting point from which parties can take matters forward. And I do think in the first instance it is for the applicant and the councils to discuss and then provide that information to the others, whether in form of a statement of agreed matters or just the draft conditions for comment. I think you indicated possibly that you'd expect that to be out at the very latest by the time of the hearing statements in the middle of April, and I'm sure that would not be a problem at all, and that would give a full month before any oral hearing sessions for other parties. But I rather suspect there will only be some of the conditions will be fairly standard, and some will be a matter of controversy or comment that may well require a oral hearing session after all other oral hearing sessions at the end of the second week. But hopefully by that time parties' positions will be fairly clear to you, and it may not take too long. It's a slightly separate matter as to how the council's other reasons for refusal are dealt with, and whether that, as they've suggested in their most recent correspondence, might be subject of written submissions or some sort of planning policy hearing, rather than getting combined with a more technical drafting of conditions hearing at the end. I think possibly on the one aspect, it may be an overlap with conditions, but if it's a more general hearing they're looking for, that might be better to be held separately and before the condition session.
Thank you, Mr. Burnett. I will come back to that question around whether or not a policy hearing should be held. So just hold that thought. Now I saw Mr. McSwiggan. So yes, I thought I saw your hand.
Yeah, thank you, sir. Yeah, I'm a little concerned that the conditions discussion is limited to present the applicant, SSEN, and to the councils, when the actual impact is really on the community. So if there's an opportunity for us to be involved in those conditions, you know, and there's a feeling, I think, emerging that just even the conversations this morning I've been listening to, that the technical expertise does not lie within these communities. That belies the truth of the objections that we put in from our community council. These are detailed technical objections that we have contributed to from members of our own communities who've done that freely, by the way. So we if there's an opportunity to do something a little bit more rounded and have community involvement in the conditions, that would be much welcomed. I speak as someone who has considerable experience of conditions not being adhered to within community projects within our community in Tealing, and you know, we would like to be able to challenge that before they off on this occasion, really, if that's possible. Thank you.
Thank you, Mr. McSwiggan. Yeah, well, yes. So to be absolutely clear, yes, so all participants are able to participate in any session. So that invite will be extended to all. Being mindful, of course, of what I said at the start in terms of there will need to be, it will be helpful to us to think about how parties kind of group together on certain interests. Noted at the start, we have 230 or so opted-in parties. Now, of course, not everybody's going to want to participate in the conditions hearing, but we need to make sure that whatever session we hold is manageable. That's not to restrict it, but it's just asking everybody involved to kind of think about how they can group to assist us in that way. Mr. Campbell, did you wish to speak?
You're on mute there, Mr. Campbell. Didn't hear what you said.
Sorry. You should charge everybody £1 when they forget to take the mute button off. It's going back a little bit on the agenda, but could I ask you to note that community hearings where they have been held in the past are most successful when they're late in the day or the evening. It is apparently the practice of reporters to require those participating to write down what they want to say in advance, which rather kills off spontaneity, but at least it shortens the meeting a bit. So would you bear both those things in mind when you're setting the time for the community hearings, please?
We certainly will, Mr. Campbell, and we will also come back because we would like to get your views today on what may be a more appropriate or the most appropriate kind of timing for that type of session. So we will come back to that this morning, if that's all right.
Thank you.
Thank you. Yes. So I just wanted to make a request. So I see there, in terms of location for the various sessions, the suggested locations for the sessions on agricultural operations, landscape and visual, and conditions are all down as either Brecon or virtual. I would have a strong preference for in-person in Brecon, given that there are issues for people in rural areas with comms, with broadband, and also technical issues arise during the morning as they already have. And I think it would work much better if we have face-to-face. Second point I would like to make is just, you said at the beginning that you were going to come back to talking about community hearings. Is that still a topic to be discussed, or have you finished with that?
Yes, no, we will come back to it. Yes, we do want to talk in quite some more detail, really, just to understand the preferences, some of the practicalities, and kind of how we would kind of set up the sort of organisation of those to make them work as effectively as possible. And that will also come back. We will also come back to kind of the question of venues and virtual or not, or virtual or in person for each session. So yeah, you certainly haven't missed the opportunity, and we will come back to it.
Okay, thank you.
Thank you. Okay, so I shall move us on. So in terms of further written submissions, we do have a few questions, principally for the applicant in relation to the impact of the development on aviation interests. Now, we have sort of fairly limited submissions on this matter, it seems, currently, but we have noted the proposed alignment would, in some cases, bisect or interfere with what have been identified as private recreational airfields. They've been identified by the applicant. And there's reference to discussions on mitigation, but not a great deal beyond that we've seen. So we want to understand that point better. So that will be the purpose of those specific questions. Now, we appreciate many representations raise the matter of need for the project and alternatives to the proposal before us. Now, we have extensive submissions already on both sides of the argument in this regard. And we haven't actually identified a need for further evidence on the matter for this reason, but keeping in mind what I said earlier about that does not reflect in any way the importance of a particular issue. However, we have become aware of two recent ministerial decisions. Now, they're both from October 2025, so they're relatively very recent. They were both made under Section 37 as well, so that's the same route as this application is being made. And we've provided hyperlinks to these decisions in the agenda. And we consider it appropriate on that basis to give parties the opportunity to consider what ministers have said in those decisions and update their positions relating to need in light of these, if they wish to. We've also identified in the agenda, which is for some will be a rather technical matter. It's unavoidably so, I'm afraid, and that's the Rayshaw Farms court judgment. Now, some of you may be aware of this recent court judgment by the Court of Session. So, in essence, it found that a reporter considering an appeal for a wind farm development should have considered, for the purposes of the environmental impact assessment for that wind farm, whether the grid connection for it was also part of the same project, which should have been assessed alongside it. So our view is that we should ask parties, for their views on the implications of the Rachel Farms judgment for the Kintore to Tealing project. And there are probably two aspects to our questioning there. So what does the judgment mean for consideration of aspects of the development which have not been considered by the EIA report thus far? So things like borrow pits, temporary construction compounds, perhaps even compensatory woodland proposals. We're not sure where the extent of that may sit. So do these need to be part of the project in terms of an EIA assessment? And if they do they require further environmental information now? The second part is also what the implications are, if there are any, of the associated projects which would be consented by other means. So by that, I'm thinking about the Emmerich and Hurley substations, the associated A-list to Tealing and Tealing to Westfield reconductoring projects, and which have now been consented, which you've just referred to, and there may be others. So, well, there are others. So we propose to set out our questions to parties in writing, and we'll consider the implications of the court judgment further once we receive your responses on that matter. We'll pause for breath and just see if there are any comments or questions or reflections on what I've just outlined there. Okay. So you'll see that we're not at this moment in time anticipating further procedure on other matters, although this may of course change as we get to grips with the evidence in more detail and we get further submissions from you. Now, Mr. Finlay and Mr. Campbell, you've both very fairly, I would say, given us forewarning that you'd like to seek some other hearing or inquiry sessions. Now, at this point, we're not certain that we need any further evidence on the matters you've outlined. We want to listen to why you consider further sessions ought to be held, and then we can take a view after this meeting. Now, Mr. Finlay, yours was a more specific request. I understand a kind of policy and or a kind of a planning balance type hearing would be worthwhile in your view. Obviously, Mr. Campbell, you've cast the net wider in terms of topics which might have dedicated sessions. So if we're focusing on the specific point first, Mr. Finlay, could you outline why the council considers a further session on planning policy would be advisable?
Yes, as I've already indicated, sir, that you don't have the council's position, a fully articulated council position on policy, and the council would be in a disadvantageous situation were it not being able to put that before you. Frankly, it would be unfair to the council that it cannot articulate its decision properly in policy terms and why it considers the balance falls where it should do. Now that can be done mainly in writing, which is why we've suggested that there should be a written representation procedure and then provision made for hearing if you consider having had that a hearing is necessary. In our view, a hearing is likely to be necessary. I covered this in part when dealing with your question on conditions. We're quite happy that that be drawn into a conditions hearing session if appropriate, or have a standalone session. The council's three reasons for objection. The first one we're going to have a oral session on anyway, but the latter two we're not, and the council is content with that because they really don't raise matters upon which you need more base information, but it's just the use made of that information and how that should be factored into the decision-making process, which you don't have the council's case on at the moment because the decision was made against officer recommendation. So that's the background. We're quite flexible and to a certain extent in your hands as to the nature of the process we take, but we consider that if there's a statement of agreed matters on policy, that should assist you in part, and secondly, that at least an exchange of written representations or hearing statements on the planning balance, and if you consider frankly, you have enough from those hearing statements, either the hearing could be very short indeed, you ask no questions, or you could dispense with a hearing. But I think it, as I said at the outset, as a matter of fairness, in some form or other, the council should be able to articulate fully how it takes and justifies its reason for objection.
Thank you, Mr. Findlay. I'll come to you in a moment, Mr. Campbell. Just on that specific point, I'd just like to ask the applicant if they had any particular comment or view beyond what you've already said, Mr. Burnett, in terms of policy type hearing or written submissions leading potentially to a hearing session.
Well, it sounds from what Mr. Finlay said that the council want to articulate their position more clearly, and obviously that would be helpful sooner rather than later. Otherwise, the sort of topic he's talking about may seem to be more apt for closing submissions. But I think if there's something they're wanting to put out there earlier, then it would make sense for them to either put a position statement or further written submissions to clarify their position on the reasons for refusal. But I agree, there doesn't appear to be a great need for an oral hearing in relation to that matter. It may be more apt for closing submissions, but once we've had a look at an early written articulation of their position, it might be easier to ascertain whether a hearing would be necessary on that topic. But obviously, exchange on policy matters, most or a lot of it can be agreed by way of a statement of agreed matters as to which policies are relevant, and then a matter of submission as to how you should approach the application of those policies. So I would agree that some sort of written submission by the council in early course would be helpful, and then you could decide whether any oral hearing is necessary.
Thank you, Mr. Burnett. Shearer.
Yes, sorry, just to go back a step to the EIA scope in light of the Reshaw Farms judgment. I think I heard you say that you want our views on that judgment and the implications for the EIA. Did I pick that up correctly? And I'm wondering how we submit them.
Yeah, that's correct. So what we will do after this meeting, so within 7 days of this meeting, we'll provide a complete note of what we've said, and we'll also set out the further written submissions that we're requesting in that note. So that will set out precise questions. So I am talking slightly in the abstract today, just because otherwise we would be getting into far too much detail. So we will set out all the precise questions that we're asking and who we're asking to respond to those questions in the note of the meeting.
Thank you.
Mr. Campbell, I'd like to give you the opportunity now to kind of set out your position in terms of further procedures.
Yes, I'd very much like to take that opportunity. I wonder if you might consider a 10-minute break. I do want to consult some of those here about the way in which we approach this rather long list. The list was deliberately comprehensive, or intended to be comprehensive, as you put it, the net is cast as widely as possible. But having listened to Mr. Finlay, in particular Mr. Burnett, I think I have a scheme in my mind. I would just like 10 minutes to consult about it before I make submissions to you on this topic. Would that be all right?
I think, well, we've been going over an hour now, so I think it's probably as good a time as any, Mr. Campbell, if that assists you. So yes, so if we take 10 minutes now, so we'll rejoin the meeting at 11:20. So if people can not leave the call, please, but you can mute yourself and turn your camera off, and we will start promptly in 10 minutes time. Thank you.
a little while ago was deliberately sent in advance so that you wouldn't be ambushed by long speeches by me about the importance of this topic or that. I hope that's been helpful.
It sounds, yes.
The list of topics comes from really two sources. The single objection document, which was lodged in objection to the application at the application stage, and also my consultations with the members of the groups up until today. And our perception is that each of these topics has been either inadequately dealt with in the environmental impact assessment or not dealt with at all, and therefore the inquiry needs to have more information about these various topics. Now, I'm sure you don't want to sit listening to me for an hour or two to talk about each of them in turn. I detect from before the break that you're moving towards a situation where parties would offer you written submissions about the importance of their own topic, and then you would make a decision about the form of examination. And that would range from no further procedure right through to hearings or inquiries. Can you tell me, is that a correct understanding?
Yes and no. So there are particular topics where we feel like we require further information to be able to decide whether further procedure beyond that will be required. We haven't been envisaging on asking a more open-ended question for essentially kind of more extensive or expanded representations on any matter to be submitted.
The problem with that, sir, is that you can't know that you have enough information until you know what everybody has to say about a point. If I take, just as an example, the public health point, I'm quite sure that in the environmental impact assessment, there may be some reference to public health issues, but there is a particular view in this third-party group that the topic is not adequately covered, and a wish to inform you further about matters which are not covered thus far. So that's why the list is what it is. Now, to try and move this on, what I'm going to suggest is that when you make your directions after this meeting, you should direct that no teacup should let you have a short, and by that I mean not more than a page, submission on each of these topics, so that you're informed about the bones of the argument they want to make. And then you can decide, or you're fully informed about whether or not there should be further procedure that you want to investigate. So that's my proposal. And I can promise you there won't be long submissions. It would be deliberately short and structured in such a way that you can absorb what No Teacup is saying quickly and help you make a decision.
I'll come to Mr. Burnett in a moment. I mean, we will, if we went down that particular route, we would need to be very mindful and particularly careful that we are not essentially providing a further opportunity for representations to be made, which has already passed, and we're now in the process, as you'll appreciate, of the inquiry into representations made and the consultation responses. Not a further opportunity to elaborate upon matters which could have been included in those representations.
Well, it wouldn't be a novelty for parties to an inquiry to address a matter in more detail than it had been addressed hitherto.
Certainly not, but it would be, that would be the case where we are having further procedure on that topic. It wouldn't be an open-ended opportunity to comment further on any matter. No. I can see some benefits of what you're proposing to Mr. Campbell. It will mean this is something that Mr. Liddle and I will need to discuss carefully before we make a finding. So you'll appreciate you won't expect a decision on that point today. But
no, I don't want. So,
yes, absolutely. Mr. Burnett, would you have the applicant's view on what Mr. Campbell's outlined there?
Well, sir, I mean, ordinarily the decision on further procedure is taken as a result of the discussions at a pre-inquiry meeting such as this. And we've already discussed one or two topics where you may require further written submissions in order to make that decision. But in my submission, most of the topics listed are adequately covered in the information and representations already made to you, and you've already identified perhaps on the second half of Mr. Campbell's list that you may need to hear a little bit more about the racial issue and potentially the need issue. But the majority of the other issues listed are all matters where there's a great degree of information available and representations already before you. And although I don't want to ask Mr. Campbell to make hours of submissions as to why you need more, it is a matter for you, and I would be reluctant to get into a exchange of written submissions as to why there should be further procedure in relation to these matters. It is for you to decide how much more information or representations you require in light of all the information already available to you. So I would advise caution in getting into a round of written submissions about what the further procedure should be. But obviously, if Mr. Campbell does make short submissions on that, we would like to respond to that.
Thank you. It certainly is a matter for us to decide. Mr. Campbell, I mean, in the list which you provided us, and yeah, thanks again for having advance notice of that. So I appreciate you set them out alphabetically. But I mean, in terms of kind of particular matters which you have a kind of stronger view that further procedure is required. I mean, are there particular matters which you would wish to kind of draw to our attention?
Well, I've only included matters in this list which I want to talk about at the inquiry, not because that they're casually or causally related to the topic of the overhead line. Obviously, some are of more importance than others, and that's why it's set out alphabetically. If you take the gas pipeline, we perceive that to be very important. It's treated very casually in the environmental statement, and we perceive it necessary to say more to you about that. But it is the adequacy of the environmental statement which has prompted this desire to make additional submissions on these topics. Some of them may be treated very shortly. If we look at the matter of military remains, for some people that's a passion, but for others it's a topic which can be treated quite shortly. And by that I mean a small number of pages. I wouldn't dream of suggesting that there should be an oral hearing on that particular topic. But I'm not going to get into the relative importance now. I arranged it up them alphabetically for that reason.
Okay.
So I think you can see my position.
Yeah, absolutely. No, I completely understand. So we will take stock, I think, in terms of what's been said this morning on these other matters and whether they are omissions which we need to address, and if so, how that might operate. And we can take it from there. So I think, yeah, so we'll certainly set out in the notes of our meeting what our intention is in relation to all of these matters, Mr. Campbell. So you've got that clarity. Although I would note now as well that this doesn't affect our decision in that regard, but the community hearings offer the opportunity for participants to say what they wish to say to us and to draw attention to matters which wouldn't be within the scope of the week 2 sessions. I'm not using that as a means to avoid getting into more detailing on the matters you've outlined there, but it does give an opportunity for things which may not be covered.
I do see that, but the reason that these topics are listed here in this way is to avoid the rather scattergun approach which may come from saying there will be a community session in the evening in Kintore or Tealing or wherever it is, and not quite knowing what's coming forward. The idea of doing it this way is so that you have as much foreknowledge as possible in as concise a form as possible. Because our job, after all, is to help you be informed. And
Absolutely.
the persuasive part of what we do comes later. But at the moment, it's to help you be informed. And that's why this is arranged as it is.
Thank you, Mr. Campbell. Okay, I intend to move us on, and I shall hand over to Mr. Liddle to pick up hearing.
So we'll move on now then to item 4 on the agenda. To a certain extent, I think 4 and 5 may run together a little bit. There might be a little bit of recapping of what we've discussed, so I'll try and do that quickly and need to dwell too much. So, participation in further procedures. I just want to emphasise that all parties who are opting in to being involved, or who do opt in to being involved going forward, should understand that they will need to prepare and submit their case in writing in advance. It's just to allow the other parties to see what evidence is being presented and to avoid any surprises on the day of a hearing or inquiry session. And some parties may wish to rest on their existing representations or evidence, of course. I suppose worth reiterating, we'll take into account all of those written representations that we already have. So no one's required to participate in all of the sessions that we settle on, nor should they feel that they have to. In our view, as we've said, the second week of sessions will tend to be better suited to those with technical expertise, professional representation, but I do bear in mind what's been said. Need to avoid too much focus on technical evidence, and that's certainly not our intention. So that said, the community hearings would, we think, provide a more accessible means for other groups and individuals to participate. So we'd encourage those who fall into this category to seriously consider focusing their participation to those sessions. So for the community hearings in particular, some parties or individuals may also find it helpful to group together with one party taking the lead. We do understand the strength and indeed depth or the feeling that exists. There are many objectors to this application, but there is, to a degree, a limited value in us listening to the same concerns or arguments multiple times. By grouping together, it's likely that in a community session, we would be able to offer the speakers more time individually, and that may allow for more detailed and recent representations to be made. So perhaps something for people to think about in terms of the possible benefits of grouping together. So just quickly recapping, I think we've covered off we've discussed the issue of agricultural operations. For all of these sessions, with the note of the meeting, we'll be inviting people to confirm which sessions they need to take part in. So you've got an opportunity to think about that. Discussed agricultural operations. I think we've also discussed the issue of landscape and visual effects. And again, at the end of this, when we issue the note, people have a chance, then the opportunity to say which sessions they want to use. The only thing I wanted to add in terms of conditions in the same vein is that I think it was Mr. Burnett who mentioned there is a set of model conditions, if you like, that our colleagues in the Energy Consents Unit of the Scottish Government have prepared. So as a first step, we would send these out to the interested parties in the condition session, and we'd expect them to at least that serve as a basis for a suite of conditions. Of course, they may need to be altered. As we've already mentioned, there are 2 planning authorities involved here, but that at least should be a starting point for the positions, for the conditions. So we will issue those with the note of the meeting or shortly afterwards. Okay, so I suppose the last thing I wanted to say, just in terms of item 4, and just to reiterate that parties do need to confirm their participation in the sessions after this meeting. So when the note comes out, we will give parties until the 10th of April to confirm to us what sessions you want to be involved in. And if we don't hear from people, or if they don't confirm their participation in their procedure, we'll assume that you're opting out of that part of the process. So if I can move on then to item 5, which is about the dates, the location, and the duration of the evidence gathering session. So you should regard the weeks of the 15th and the 22nd of June as fixed for the inquiry. Otherwise, we'll be into the school summer holiday period when it's likely to cause difficulties for some who might intend to participate in the inquiry sessions. So we do have some limited flexibility on the exact dates and the time of day. I'll come on to that for the community sessions. But we're expecting the timetable that we appended to the agenda to be workable broadly. We've proposed to hold the community hearing sessions in person, and we've suggested Kintore, Brechin and Tealing as possible locations for these, although the availability of a suitable venue, particularly in Kintore and Tealing perhaps, may dictate that we may need to look at alternative locations. And I'm going to ask parties' views on these things in a moment. The size of the venue might also be dictated by the precise way in which the community hearings are organised. So in terms of that format for the community hearings, as we see it, there are two main options. Conventionally, we would run a community hearing so it starts at a particular time, sometimes in the day, sometimes in the evening, and all participants and observers would be expected to be there at the start and to stay for the duration of the session. Now, an alternative option might be, maybe we could explore whether we could offer slots for those wishing to speak. So people wishing to speak would choose a time slot, probably on a first come, first served basis at one of the 3 community hearing sessions. Now, strikes us this would be less of a time commitment for individuals, and it may also be less intimidating environment for those wishing to speak, as there are likely to be less observers at any one time. And this approach might also enable smaller, more local venues to be used. Those are just our thoughts. We very much welcome your views on these 2 options and whether an evening or afternoon would suit best. So I was going to, at this point, seek views. I have in my mind the community councils, most obviously in terms of being able to represent community views on this point, but maybe if people do have views on broad locations for the community sessions, possible venues, and indeed the format that we've talked about, a kind of more single meeting or the ability to book slots. And the other thing is evening or is perhaps the afternoon going to suit best? So I really wanted to just gather views on these questions just now before then we can go away and reflect. So I see some hands coming up, so we'll just take it in order. Ms. Matthews first, please.
Hi, thank you. I think a mixture of afternoon and evening sessions gives people the opportunity to attend when suits them best, and possibly the appointment slots is a good idea because people obviously have busy lives. My biggest concern is that there are 3 named venues at the moment, which is Kintore, Brechin and Tealing, and I'm not sure if you're aware of the geography, but there is 49 miles between Kintore and Brechin, and there is only 22 miles between Brechin and Tealing. And I wondered if there was possibility of putting a hearing in Stonehaven, which is that missing quarter of that line. So it's approximately midway between Brechin and Kintore.
Okay, so that would be in addition to Brechin, not instead of Brechin, was your suggestion?
I think if it could be an addition, that would be better. But if it can't be an addition, then somewhere in between Brechin and Stonehaven would make it more accessible for people, because it's quite a distance to be travelling. I see you shaking your head, John.
Okay, so that's helpful. And I'll go on to Ms. Bick in a minute. But I suppose I would just say to people, there's one suggestion that's been made by Ms. Matthews. If other people have a view on that, then by all means come in that. Don't just restrict yourself to the questions that I initially asked. respect, please.
Thank you. Yeah, so I would agree with Kate that that Brechin and Tealing are both close together and very far down the country, whereas Kintore and the area between Kintore and Brechin is not very well covered in terms of this the proposed sessions. But what I also wanted to ask was, what facilities do you need your venue to have? Are you expecting the venue to have broadband and internet connection? Presume you are, but could you just confirm that?
Yes, I think that would be helpful. I mean, the most obvious thing is they have to be big enough for the numbers that we're going to anticipate. They wouldn't necessarily be webcast, and that's often been a driver for us for having good bandwidth and good connectivity for a venue. Other parties, though, will certainly a more traditional hearing and inquiry would tend to feel connectivity is important so as they can keep in touch with their teams and so on. I think that's probably less important for a community hearing session when people are individually giving their views. So I think it would be good if there was good broadband connectivity, but it's perhaps not essential, and particularly if we don't end up casting these.
Can I just say that I think you should webcast them, and therefore the venue should have connectivity, because if you webcast, then there are people who want to be present who won't actually need to be in the room, and therefore your venue won't need to be quite so large.
So, yeah, I mean, I think when I say webcast, what I mean is simply broadcast rather than have it as a meeting which is both virtual and in person. I think all the participants would need to be our preference would be certainly that all the participants would be in the room. The purpose of broadcasting it is simply so that non-participants can observe it rather than can participate virtually. And I'm certainly not averse to doing a webcast. One of the constraints for us is simply staff time and our resources and our ability to within the small team that we have to service a number of inquiries and so forth over the year. So it might not be possible that we could webcast every one of these sessions over to just simply for staff. Certainly staff resources is an issue for the bill, an issue for us to consider in that. Okay, Mr. McSwiggan. Oh no, I'm sorry, Ms. Morrison.
Hi there. I'm just wondering how big a venue you're actually looking at in Kintore, because our biggest venue is the public hall, which usually, if you're having a big meeting, it's only usually 100 people you can get in it. So are you looking at something bigger than that? Because if so, you have to go in Inverurie then.
So, I mean, that's $1 million question. There are, what did we say, 230 people who are opted into this process. So if you divide that by 3, then you might expect most 70 or 80 people on average a session. Not every person who is opted in we wish to take part in the community sessions. On the other hand, some people want to come and observe them. So 100 people might be tight, to be honest.
Yeah, that's what I'm saying. That's why we go to Inverurie then.
Mr. Campbell, sorry, can I ask you just to mute your microphone just now? It's just we're just getting a little bit of feedback. Thank you. Yes, I mean there's a balance. We want to. I think everyone would want these events to take place as close to the communities that are affected. But on the other hand, we need to find a venue that's going to be suitable. So it's just striking that balance, and that's why I think you'll have a better feel for that the local than we will about what's doable and what's the most sensible approach. So you would say
I would say Inverurie.
Inverurie rather than Kintore.
Yeah.
Okay. Okay. And again, if other people have thoughts on these issues that are getting raised, then you can put your hand up again, even if you've already spoken. That's fine. Just want to hear people's views. Mr. McSwiggan.
Thank you, Mr. Little. Yeah, the Tealing Community Hall, Community Centre Council, should I say, we're more than happy to host it in Tealing Hall, which holds just over 100, 150 if we're standing in it. The question I was asking really is around the observers. When you say observers, who do we mean by that? Just people, anyone coming, or are we expected to have representations from SASEN and the representatives at these meetings as well?
That's an excellent question. So certainly anyone is entitled. This would be public inquiry session or a public hearing session. So anyone who's a member of the public and wants to come along and observe would be able to do that, subject to the hall being big enough, of course. In terms of the applicant's kind of role in this, at community sessions, I think we've tended, and I'll maybe come back to Mr. Burnett on this. I would expect that we would invite the applicant to attend, because I think it's fair that they hear the opportunity to hear what is said. Sometimes when we've done these community sessions in the past, the applicant has had the ability to ask questions or ask clarification, for example, of a point being made. I think other times the applicant has been there simply as an observer and has not had the opportunity to participate. I think we've got a fairly open mind about which is best. But you know, I wouldn't anticipate the applicant having a very prominent role in a session like this, because the point of it is more to hear from community views. That's the main purpose of doing it.
Yeah, that's helpful. The reason that I ask really is I'm anxious about the presence of SSEN in the community centre. They haven't been particularly well received since their consultations locally, and I think that it could turn into, we need to be quite careful that it doesn't turn into sort of like a diatribe against SSEN locally. So I'd be really cautious about their representation, and certainly not coming to it mob-handed as we've seen in other things that we put on for the community. So yeah, we're more than happy to do that. Thursday, I think you mentioned for Tealing that would be Thursday the 18th. Is that, have I got that right?
Yes, that was our suggestion.
Yeah. I mean, I'm just checking to see what else is on. You could be interfering with the line dancing or something like that, the dog training or whatever. I don't know what's going on that evening, but I have a way to try to find out. I'll get back to you on that. And I'd also like to thank you for sparing me from the World Cup. I hadn't intended to go to the USA for that, but I've declined now. But you probably saved me a few bob and some heartache. So thank you for that. Okay.
Glad to have seen this. Okay. So yeah, you raise an interesting point. I mean, we would like this whole session, all these sessions, to be run in a kind of manner where everyone's respectful of everyone else's views, and where we let each other speak. And so that's how I'd expect the community session, albeit we understand that there are strong views. But this is, you know, if we are to get the best evidence from people so that we can properly advise ministers, then it's sober and considered views that we need to hear at these meetings, rather than anything more heated than that. We'll come back to Mr. Burnett, but I do want to just hear from community representatives first of all. Mr. Campbell.
Just a short point. The largest percentage of representations, I'm told, came from D-side. Kintore, Brechin and Tealing are not on D-side, if my geography serves me correctly. So Ms. Patterson is with us, and she's involved with Banbury Community Council. I see also we have the benefit of Mr. McIntosh's presence, and we know that the Banbury Hall works well from recent experience. So that might be a venue that you might want to consider, thus achieving a broad equivalence between Aberdeenshire and Angus. That's all.
Okay, thank you. Yeah, sure, quite right. I think most of the public representations come from Aberdeenshire as opposed to coming from Angus. Quite right with that. I haven't filled down more detail about where they are in Aberdeenshire. Mr. McIntosh, please.
Yes, a couple of points just to make. I would actually say that, and in fact, as Mr. Campbell has indicated, and quite a few people on this call have been involved with some recent inquiries. And first of all, I would say that the conduct and the way that the communities attended those were exemplary, notwithstanding that they were contentious, as was the conduct of the applicants. So I'm quite confident in our communities and the applicants that we can have a well-reasoned and conducted hearing run by yourselves. In terms of venues, I do take Mr. Campbell's and the Aberdeenshire community's points. We have various venues. We could use Banbury Town Hall is one. Mr. Campbell will be delighted to know that it's recently been upgraded, and we've now moved from having 4 sockets to about 20. So we won't have the spaghetti junction that that's threatened to electrocute half the legal profession involved in planning. So there is that venue. There is Stonehaven Town Hall, and there's also venues in Inverurie. I would defer to our communities as to where they would wish, but we'd certainly work alongside with them to make sure an appropriate facility could be made available. I would also say in terms of numbers, I would not underestimate that, because at the last inquiries, although there were many who may not have lodged a formal objection, will turn up. And that last one in Banbury Town Hall, they were literally queuing out the doors. But people were very gracious and went home to view it, to view the live recording. So again, I think it's a well-run community event will assist all parties, and Aberdeenshire Council will be more than happy to make sure that goes. But like I said, I'll defer to the communities as to where they would prefer that to be. That's maybe something we can liaise with very quickly and get back to the DPA.
Thank you. And just on that point you raised about your experience of Bankery and the large numbers, do you feel, notwithstanding what I've said about our capacity, that having it webcast live would help if it's a question of a venue where there are, maybe more people wanting to view it than can attend and can fit in the room?
I think that would assist, although I think we were a bit overwhelmed by the amount of numbers that turned up. But what assisted those that turned up, they weren't too frustrated because they could go home and watch it. And Bankery's got very good, strong broadband and Wi-Fi capacity for live streaming. So we've already looked. I think we did live stream that community event.
Thank you. That's good. We can go on and have a conversation ourselves and ability to do things. Ms. Shearer.
Yeah, it's just a very quick one to say that on behalf of our community, we would really support a hearing in Banbury Town Hall. It would be very convenient, and it would allow people to participate.
Okay, thank you. Mr. Grieve.
I seem to have managed to put my hand up and down a few times. Sorry, incompetence, basically. Just one thing occurs to me, and I heard the points about where the majority of the objections had come from, but surely the fact of the matter here is that the substantive objection to the Angus Community Council was within Angus. Therefore, to me, it seems to make sense that we have at least two events in Angus to try to draw people together from what is a very diverse rural area, all the way from the top of the Glens, just about in Ballater, up to the fringes of Dundee. So I think anything that doesn't take account of that risks being a wee bit lacking. And I know it's difficult to cover it all, but I think that aspect of close to community is really important there, and providing a chance for people to contribute, because I think that also affects participation as well. If you look at the planning hearing, that was particularly well attended. There was a strong turnout for that event, because that's what we were encouraged to do, and that was where people were focused. So I think there were effects there. I do also take the point about Steve raised of whether SSEN would be there or no, or would they get chased.
well, I think that there might be a risk of them getting chased, right enough. So we might have to be a wee bit careful there. But the point I would have there is it's making sure the right people are in the room for the right reasons, so that we don't get a disproportionate risk of overload or perceived authority, which has been a bit of a problem in the past. So to let people feel that they're free to contribute properly, I think is going to be a real challenge to make sure we get that. And if we go back to the planning hearing, a strong part of the case on that day was just that strength of feeling at the community level, as to why this was thought inappropriate. So I think that's an important part of the whole process, and it's the reason why we're here today. So I wouldn't really say any more than that. It's probably said plenty already.
No, it's a good point you make. So that, because there's two things. Yes, we're trying to find the sweet spot, if you like, of matching the right use to the right communities, and we want to make it accessible, but we also have to make it manageable. In terms of the reason why we're here, you're quite right. It's Angus Council's objection that formally triggered the public inquiry. However, ministers have decided that the inquiry is into the whole line. Therefore, we need to take account of effects along the length of it, and take into account community views of that. And of course, we also will have the week 2 sessions, which are more focused on the reasons for it, the objection from the council itself. So there are always two aspects to it in that sense. So yes, because I'm just come back to the first point. We I think had come in and said Kintore, Brechin and Tealing. We've talked about Bankery, we've talked about Stonehaven, we've talked about other places. We'll be robbing Peter to pay Paul. So we just need to find the right balance, I think, the right kind of selection of locations that people think is fair and reasonable. Albeit wherever we choose, that it won't be suitable for every single person or ideal for every single person. Ms. Patterson.
Yes, thank you. Given the very large number of people who are interested in this public inquiry, I think there were over 11,000 objectors, and the very large area, I wonder if you wouldn't consider 4 community hearing sessions. In a recent public inquiry, we had the community session on the Monday evening before the work started during the week, and that worked very well indeed. And I can certainly follow up in Bankery to see if there's any availability during that week. Thank you.
Thank you.
Yeah, I'm going to have another. But I just want to just reassure you that I have no concerns at all about community chasing SSEN out of town. There's more an observation, really, a concern around people being free with their comments when there are people observing them. That was more what I was coming at. We've had a large number of consultations over the years with energy developers in Tealing, and they've all gone very smoothly and with no concerns. The question I was coming to really is the duration. How long is the session in the community for? Is it an hour, 2 hours, 3 hours? How does it, what's the duration for it?
Yeah, I mean, we haven't tried to pin that down. It probably depends on the amount of interest we get for each session. They might be different. If we have a book a slot type session, like a school parents night type idea, then it might extend over a longer period. Whereas if it's a more traditional form of meeting, it might be, I think a couple of hours is probably tended to be the kind of default.
Yeah.
I don't know. It might have been different in the past. It's probably something in my mind. The other option, depending on what is suitable for people, is that we might have short session in the afternoon and then a short session in the evening. If that, if limited one or the other would be too much, would be suitable for people. So it really depends on level of interest, I guess, and how we run them.
would it be helpful then if we maybe prepared a draft agenda from Tealing, linking in with the local community councils that we're connected with in our area, and we could perhaps propose a sort of a timetable and topics that might want to be covered, and we can get that to you reasonably, certainly before the 10th of April.
So, yeah, we'll have a think about that and discuss it. That was something that we had in our minds. To what extent would it be sensible to ask the community councils in an area to go away and think of what's the best format for their area and then come back to us? So I don't know if other people think that there's mileage in that idea, but I can certainly see sense in that as a way forward. So we'll consider that. If anybody else wants to make a comment about that, then great. But if I can just pass on, is it Ms. Martin? Is it your hand?
Yes, hi. Yes. I was just wanting to back up Mr. Grieve in acknowledging the fact that Angus community is quite a wide community, and keeping a venue in Brechin might be a good idea for attendance for the local area, and probably Brechin City Hall.
Yeah, thank you. Well, I'm getting a sense that it's maybe bigger venues in the slightly larger settlements that are maybe going to be more suitable in terms of size and accessibility than the smaller venues, maybe in smaller communities. Okay, Ms. Vick.
Yes, thank you. I would just wanted to assure the community councillors in Angus that the strength of feeling against this development is just as strong in Aberdeenshire as it is in Angus, and that the response of no objection by Aberdeenshire Council was made in delegated powers and did not reflect the views of the community. And I have to say that I've never had such a huge reaction to a proposal as we had to this overhead line when it was first, and continued throughout the consultation period. In light of that, I think you should have 2 hearings in Aberdeenshire and 2 in Angus. Thank you.
Okay, thank you. And finally, perhaps Ms. Matthews, I see your hand up there.
Yeah, just to reiterate what Fiona said, and Sue, I think there should be 4 dates, and I think that geographically along the line, it's Kintore, Stonehaven, Brechin and Tealing. That's what makes most sense. It's where the bulk of the community objections have come from, and it makes it more accessible for those directly impacted communities to have a choice of where they wish to go. Every person's going to be equally between 2 points, so they get to choose and potentially attend both if they wish to do so. I think that's fairest.
Okay, thank you. Okay, it's been really useful to get community views. Mr. Burnett, from the applicant's point of view, having heard that discussion, any observations at this point?
Just a couple, sir. I think that's been a very useful discussion, and obviously in regard to the guidance given in guidance note 20 by the DPA, there's a couple of matters. I'm assuming that there will be a deadline set for the hearing statements to be submitted to you. I think you've got it in your appendix 2 as the 15th of May, and then you might be able to help manage what might be a difficult task of giving slots or time slots to people who want to be involved. The applicant has no view on where the meetings are held. In geographical terms, we're happy to go wherever they are. But again, the guidance note suggests some discussion of the level of involvement of the applicant is appropriate at this meeting. And I think I'm getting the sense, as I expected, that the applicant would like to attend to listen to what the communities and representatives had to say, but understand that we not want to come mob-handed, as someone put it, and that would be our preference as well. But with that in mind, I would also agree with those who have suggested that a venue with good Wi-Fi and the webcasting of the session would be helpful so that other members of the applicant's team can also watch and hear what people have to say about the application. And it also allows members of the public, if they're not able to attend in person, to watch what others are saying. And I think that would be welcome and should be welcomed by everyone, that everyone gets a chance to hear what's being said. So I would ask you to bear in mind that a venue with that facility, not for a hybrid hearing where other people could take part from outside, but where they could at least watch what was being said, would make sense for everyone, both the applicant and the communities and the people who've made representations. So I would strongly ask you to do that.
Okay, thank you. And can I ask, in terms of do you have a sense for, on behalf of the applicant, would they want to be there simply as an observer, or there but with an ability to ask a question of clarification or make a point when they're, just so as I understand how you envisage that working?
Well, sir, in mind of what was being said, and I think what you're suggesting, we would certainly like to be there with a small team, but not a team to cover every topic. So we wouldn't expect to be questioning or responding to all the topics there. And we would hopefully just be in listening mode, but we would obviously, if something particular came up, have the option to ask you to ask something by way of clarification. We don't intend to ask to question anyone who's giving representations, but there may be something that we would like to know more or clarify what they're saying and ask you to ask that. But we don't intend to, be interventionists. We'd intend to be there merely to observe and listen, not to take a great deal of part, assuming that you are satisfied with you are getting the information that you require.
Okay, thank you. No, that's understood. Ms. Matthews, I see your hand.
Sorry, the mistake.
Good. Okay. So not sure in terms of, no, I don't want to prolong this too much, but one of the two options were a traditional meeting, if you like, and this ability, maybe this model where we are asking people for to put a time slot in. Are there any quick views on which of those two might work better for communities? Mr. Campbell, did you have your hand up?
Yes, time slots don't work because people don't keep the time. You're far better, if I may respectfully say so, to have an evening session, say starting at 6 o'clock, and not setting necessarily a closing time, letting those who come, who've submitted stuff in advance, read their papers, answer questions, if any, from the reporters, and then go away. If you give people time slots, they'll be late or they'll overrun, and it will degenerate, I'm afraid. It's much better to have an open, free session.
You're describing my last experience of a school parent night exactly, Mr. Campbell.
I think we've all been there, yes.
Okay. Okay, great. Let me just recap. That's been a really useful discussion around the community sessions, and we'll just go away and have a think about all of that. There's a lot for us to actually discuss there, I think, between us. Okay, so if I can maybe move on then to week 2, I think, of the inquiry and hearing sessions. Well, hearing sessions, maybe. As these are, as I've said, as these are more technical specs, as I think we're suggesting, hopefully, that we haven't given enough time for community hearing sessions. We're not necessarily anticipating a large number of participants in the week 2 sessions. It strikes us it might be appropriate and more efficient for all participants in these sessions if these are held virtually, particularly given the linear nature of the project and the distance it covers. We'll only be able to have one venue to deal with landscape and visual effects if we do it in person, and that might be the best way. But the flip side of that is that a single venue for something like that may not be terribly suitable for everyone. Now, If we do it in person, our thinking was Brecon would be an appropriate option for this second week of the inquiry. Certainly noting that it's Angus Council's objection, as I think Mr. Reid mentioned, that that's what's caused the inquiry, and that's really precipitating those second week sessions. There's probably more likely to be a suitable venue in Brecon. So just thinking about those second week sessions, I just want to get people's views on whether they think a virtual sessions rather, or in-person sessions would be best. And Mr. Findlay, it's the council's objection, so I'm going to go to you first, if that's okay.
So I think our preference would be in person at Brecon. One would assume it's likely that the sessions will be webcast if they're during the day, so that should cater for people up and down the line being able to access the hearing. But our submission is that in-person hearings are tend to be better and are more conducive to proper exchange of information.
Okay, thank you. Mr. McIntosh, I know Aberdeenshire's involvement will be limited to a hearing condition session. We have one. Any thoughts on that, virtual versus in person? And bearing in mind we'd be dragging you down to Brecon.
Well, to be honest, that's not going to be very far for me. I'm just up the road from Brecon in Inverbervie in the coast, so it's not a big trial for myself. We'll be attending. Speaking to my planning colleagues, I think we'd be more than happy to attend in person, and we would hope this is in respect to the hearing condition, and we would hope by that point that we would have narrowed it down just to those that we can't come to an agreement.
Okay, that's good. Thank you. Mr. Burnett, for the applicant, any view on this?
Yes, I think the preference of the applicant would also be for in-person hearings, particularly in relation to landscape and visual. It's slightly easier to explain things in person, and also in conditions. It's quite useful sometimes to have the people in the room to interact as well. So I think we would have a slight preference for in-person hearings rather than virtual hearings for those matters.
Okay, thank you. I see, Mr. Campbell, you've got your hand up, and then after that, I'll see if there are any other views. But to you, Mr. Campbell.
I'm in agreement with both Mr. Findlay and Mr. Burnett. The in-person session for these topics is much to be preferred.
Okay.
Peter's breaking out.
Okay, well that's clear then. We can see where we're coming from. I don't think necessarily we've resistance to sense what people are saying. Okay, so just to pick up then quickly then, so where we've got to. So for landscape and visual matters, we've allowed 2 full days at this stage, which we think should be ample. It ultimately will depend on how many people tell us they want to take part in that session and how many would rather go to the community sessions instead. We're thinking up to a day each, if we need one, a session for the session on effects on agriculture, likewise on conditions. Certainly, usually a condition session is a half day. And we've maybe the potential for another day if we have a hearing on the policy issues that we discussed earlier. So in terms of site inspections, as we've already said, we've made fairly extensive site visits. As much can be done over 2 days along the full length of the line last week. And we will certainly have further unaccompanied site inspections. We haven't been to every location to view the line from. Now, in due course, we may liaise with individuals and the applicant to arrange any accompanied site inspections if we find these to be necessary. So, and I think we said earlier, we've already had some requests for that. I think it is important to stress that site inspections aren't a hearing on site. They're not to provide an opportunity to discuss the merits of the case. And so we only usually require accompanied site inspections to access private property in order to, for example, assess the visual effects from that property. It's not so that we can have a discussion on site. It's just so that we can get to where we need to get to see the effects. So in closing this item then, I'll just make clear again, as I indicated earlier, final decisions on all of these procedures will be made by us following this meeting. We'll set out those in the note of the meeting, and then people will be asked to then confirm whether or not they're taking part and in which. Okay. Oh, sorry, Mr. Campbell, you have your hand. Oh, you're muted. That's a pound, Mr. Campbell.
Fair enough.
No, thanks.
You can get rich on me. Can I ask you what you mean in Appendix 1 when you refer to agricultural operations? Mr. Thornton Kemsley made the point very clearly that agriculture per se has been scoped out. Do you mean in Appendix 1 agricultural operations including the operation of heavy machinery, or do you mean something different? Because there's a reference to Appendix 2, but I've looked in Appendix 2 in vain and I can't see anything about agricultural operations. So slightly in the dark there. I'm just wondering what you meant.
So I'm not sure if I'm understanding the question. So I'm talking about Appendix 1 of our meeting note, yes. Sorry, of the agenda.
The agenda, yeah.
When I suppose agricultural operations there is, I guess, shorthand for all of the things all of the concerns which have been expressed to us in relation to how this will affect agricultural operations. So does that, and I'm not sure if I'm answering your question correctly there. Mr. Warren might be with.
I hesitate to say no, but I don't quite follow what you mean when you use the phrase agricultural operations in Appendix 1. Either you're referring to farming per se and the impact on farming, or perhaps you're thinking about impact on farming land or farming people, or indeed the use of farming machinery. There are a lot of aspects of this which are to one extent or another controversial. So I'd just like to be clear, if you're going to allow a hearing on this topic for a day, 23rd of June, what the scope of that hearing is going to be, because it's clearly an important topic. And you've already heard from Mr. Thornton Kemsley about that.
If I may, Mr. Campbell, yes. So this links back to what we discussed earlier in terms of seeking the clarification from parties in the first instance through further written submissions on the matters raised, particularly by yourself and Mr. Thornton Kemsley.
Mm-hmm.
So we can understand precisely whether or not is there a kind of scoping deficiency, and whether or not we need to explore matters further through the EIA process. Mm-hmm. And then depending on the those responses and the view that we take, having received your responses to that, the applicant's response to that, we will then decide whether or not that hearing scheduled for the 23rd of June, you see in the appendix there, it was in brackets if needed. That would be the follow-on from those further written submissions, depending on whether or not we need to ask further questions on the points raised.
Very well, thank you. That's most helpful.
Great, thank you.
Okay, thank you. Okay, thank you for bearing with us. I'll move on now to item 6, which is the last point in the agenda. We'll get a few more things to cover after that. So this is about timeline and the deadlines for various aspects of the process and about document management. So the whole process is designed to be fair and open so that everyone has access to the same information on which decisions we made. So we've set out our timeline of key milestones, the deadlines for documents, and that's in Appendix 2 of the agenda. This ties in with our assessment of procedures required and reflects EPA's guidance note 29. Albeit we've discussed some of these matters today, so there's maybe modifications to be made in the light of those discussions. I'm just going to take a few moments to go through the process this now. So in our note of this meeting, or soon afterwards, we'll set out precise questions, picking up your point there, I think, Mr. Campbell, that we'd like to be addressed in the further round submissions. Now, the deadline for these submissions will be the 24th of April, and then there will be a further 14 days for parties to comment on each other's responses, and that takes us to the 8th of May. In parallel to that, we'll be looking to the applicant to compile and finalise what we call the foundations document list of foundation documents. So these are the documents that we need to have regard to in making our report to ministers. And we've provided the applicant with an initial list to assess with this based on the documentation that came in with the application. It's important that this list is in place as we can, because it will enable those providing further representation submissions to rely on and refer to the documents in that central list that we can all refer to. And that's much better than everyone producing, multiple copies of the same document as we go forward. So we ask the applicant to liaise with the other parties to ensure that documents that other parties want to put in this list can be identified as early as possible. And assuming that most parties at this meeting will remain opted into the process, those discussions take place straight away, I think. Angus Council has suggested that we also have a statement of agreed matters, it's responding to that notion. So just for those who may not know what that is, this is typically a joint statement from a number of parties setting out the agreement on things like, for example, the scope of the project, the policies which are applicable, and perhaps the extent of significant environmental effects or otherwise. This is the purpose of that is simply to avoid time at the inquiry discussing things which we can agree beforehand. So we will ask for this, and we will ask the applicant to liaise with other parties in seeking to reach agreement on it. You don't have to be involved in that process. It typically tends to be the applicant and the planning authority, but other parties can be involved in that process if they want to. So we're suggesting that we will suggest that this is submitted on the 17th of April, along with a list of foundation documents, if possible. Hearing statements and, if applicable, inquiry statements will be required by the 15th of May, and the statements to be read out at the community hearing sessions must also be submitted by that date. And someone did make the comment about having a written statement for the community session might impinge upon spontaneity, but I think it's important that we see in advance what people are going to say, not least because so that we can better reflect people's views in our report. It's much easier for us to do that when we have that in writing rather than having to react to people telling us on the spur of the moment on an evening. If hearing statements rely on documents that are not already being captured in the foundation documents list, then that's fine. But we also need these additional documents to be submitted on the 15th of May. We'll set this out in the note. But I do want to stress that it's only documents which are critical to understanding or substantiating your positions should be provided, and these should be directly referred to in your statements where this is the case. It's not helpful to us to submit non-essential documents, and in fact, it just places on everyone if there are lots of documents submitted by lots of different parties and they are peripheral to actually the arguments that we need to think about. So it's just to bear in mind, is this document essential for the inquiry? And there's no obligation on you, particularly, for example, if you're taking part in one of the community hearing sessions, to produce any other documentation other than your own statement. So I know that's a lot of instructions to take in. Rest assured, we'll set all this out in the note of the meeting. So that's the process running up to the inquiry. Ms. Vick.
Yes, sorry. Can I just make a plea to, in regard to that 15th of May deadline for community hearing statements? Since they're not statements that the applicant or anyone else is expected to respond to or critique, and they're simply going to be read out at the community hearings, could we please have a later date of the 22nd, or put the deadline for those back to the 22nd of May instead of the 15th?
Okay, we'll have a think. Is there a particular reason for that? I mean, it's not still 7 weeks away or something.
Yes, I know. Sorry, it is a particular issue for me in that I'm going to be away for 3 of those 7 weeks, and I don't come back until the 15th of May. So, and since it wouldn't impinge on your process, I don't believe, to have it a week later, then I think that would be better.
Okay, we'll have to just have to think about implications of that. Maybe.
Yes, thank you. On the back of what Fiona Bickett just said there, we would also appreciate possibly having a delayed date, because we don't have a committee meeting until after that date of the 15th. It's actually the 17th of May, so any extra time would be helpful to us as well. But also, could you advise us on the length of statement? We're thinking, what, 1,000 words? What sort of length would you be expecting to have?
This is for the community hearing session.
Yes.
Specifically.
Yes.
And so the expectation, I suppose, is that these are read out, although one might not want to read out the whole statement if you didn't want to. So I think if we are to accommodate everyone who would like to accommodate at a hearing session, then over a 2-hour period, then they can't obviously be too long if there are lots who wish to take part. And this goes back to what I said about if the more people are able to coalesce, it might mean that we can have fewer but longer statements that we have. So that's something I haven't thought about a word count, if you like, for that.
We need a word count.
Yeah, how many words? It's a good discipline to have. I don't know whether you've got experience that in the past.
Yeah, well, so I've run a couple of sessions of this nature, and they've taken slightly different formats. And I think we would want to perhaps gauge first of all. So we've got the 14-day deadline after we've issued the note of the meeting for participants to confirm their participation. So when we know how many people are intending to participate in each session, perhaps at that point I think that's probably the most appropriate point where we could say, actually, okay, we think we could offer you 5-minute slot, a 10-minute slot, depending on
time-wise rather than length. Okay.
I think perhaps. I mean, if it's more helpful for us to give a kind of an indicative word count as well, I think we can do that. It will depend how quickly or slowly people wish to speak.
Yeah, I know. Yeah.
Ultimately, I think we're going to be in the right kind of range. Once we've got that understanding of precisely how many people we need to actually try and fit into a kind of a relatively small window.
Yeah. Okay. That's great. Thank you.
Yeah, I'm clear on the written submission, but are you asking us just to simply read that out verbatim at the community hearing, which sort of can be a bit static, really, or are we able do any sort of a presentation. I'm not sort of wanting to tell you about PowerPoint or anything like that, but there'll be nuances around perhaps things that community councils might want to submit, but drone footage, pictures, etc., etc. Landscape views, that are clear to our area that we want to highlight. So I'm just wondering, is there an opportunity to go off, to expand on that script?
So I think if for example there was a drawing or a bit of footage that you wanted to refer to, I think we would ask, and I'll just discuss this. I'm thinking it's probably doable, but we would need to have them at the same time as your statement, so as that we can see what the content is, so as that the applicant has a fair chance to see that beforehand. I mean, I don't think we would want to see footage on the night. We don't know what it is.
Okay, that's good to know.
Yeah, but we'll think about the mechanics of that and put it in the note.
Thank you.
Mr. McIntosh.
It's a thought if it would assist the communities, because I think it did on our recent Hill of Fairwind inquiry, where we provided links to some very well run and successful community hearings. I'm happy to provide those links. I think the one I just mentioned, Hill of Fair, and I think Mr. Finlay kindly sent a link to one that was run in Skye. First, there were very good, well-run community sessions, and then the various. So I could suggest a couple of links, which we're happy to share with the communities and the reporters. I appreciate every inquiry is slightly different and on its own nuances, but the feedback from the communities was they were quite helpful, having the ability to see how these have been run previously and see some of the documents that are submitted for the hearings. So I'll be happy to provide those links to share with the communities and the reporters if it would assist.
Yeah, that would be very helpful, I think. Thank you very much. Okay. So there's a couple of things for us to think about and pick up on then. So 2 weeks, last 2 weeks in June, in effect, last 2 full weeks in June, I think it is, which are for these sessions. Afterwards, we'll be asking for closing submissions from some of the parties. I think for those parties who participated in the week 2 sessions, which will be the more technical of nature, we'll ask from objectors closing submissions and a summary of their case 7 days after the last oral session. This is to provide a recap of the heard at the hearing from the party's perspective and a summary of its case. It's not about giving us new evidence, it's those that we can best reflect the party's case in our report. So that's 7 days after the last oral session in week 2 for the participants in week 2, other than the applicant, who then by convention will have a further 7 days from that point to make its own closing submissions. Now, I know these are quite short timescales after the end of the sessions, but we want to be able to then get onto write our report as soon as we can. So that's the timescales we're going to adopt. The final thing I want to say before I hand it back to Mr. Warren is just about the exchange of all this documentation. Sorry, T2 hands up before I go on to that. Mr. Campbell?
I don't intend this to be in any way offensive, but 7 days is a very short time for a closing submission after a long inquiry into a project of this magnitude. So it is special pleading, but I would respectfully ask you to allow 14 days for that purpose.
Was it on the same area?
It was, sir, especially given the number of potential participants in the community hearings and even in the oral hearings. Only 7 days is a very short time span to reply to what could be a number of closing submissions by the objectors. So I would agree with Mr. Campbell that perhaps 2 weeks each would be more appropriate in this scenario.
Okay, well, we're reflecting that. Just everyone should be aware then, not least SSEN, that has consequential implications for the speed at which we can then report back to ministers. So that's fine. We can have a think about it. Okay, so what I was going to say then was just about the sharing of documentation. So DPA use a file sharing platform called Objective Connect. So once everyone's opted in and it's confirmed they wish to participate in the particular sessions, we would send out details of how to use Objective Connect. Now, it's got advantages from simply exchanging documentation by email. It can accommodate larger file sizes. Everyone can see what's been submitted without any delay. So using that platform just makes the whole process a bit more transparent and time efficient. So send out instructions to people as to how to use that in due course. That's me for item 6. I don't see any hands up then, so I'm going to pass back to Mr. Warren just for the last few items of business.
Thank you. Yeah, so I am really just kind of wrapping up now. So there are a few kind of points just to note. So first of all, in terms of kind of contact information, so when you're communicating with the DPA, so we have several case officers who are providing administrative support on this case. So if you've worked on other cases, you may have had a named individual that you've had as a contact point. In this case, we're not going to offer that. We have set up a dedicated email address for the project, and that will be monitored by the whole team kind of working on this project. So we'll include the email address in the note of the meeting. I think you probably already have it. And now that's monitored frequently during every working day. So that should be used in the first instance, at least, for all inquiries to us. If you need to speak to somebody, that will be possible, though. So it's not just a closed door behind emails. Is there any other business that anybody would like to raise before we close the meeting? We've covered a lot of ground, so that's been very helpful from our perspective. So in terms of Mr. Burnett.
Just briefly, sir, can I assume in relation to the invitation you've got to make further written submissions on need, will that be one of the matters that you cover in the questions that you put? Just to be clear, what you're looking for in that regard to that?
Yes, it will. Yeah. So everything we've kind of outlined in the abstract today, or even where we've gone into more detail, everything will be set out precisely. Yes. So on that leads me very neatly into the note of the meeting. So we'll aim to issue the note within the next 7 days. So by Friday next week at the latest. And this will confirm all matters which we've discussed this morning. So it will also set out the further written submissions that we'll be seeking, and also any decisions that we need to take following on from the discussions that we've had in terms of further procedure there are multiple matters that we need to give further consideration to on the basis of the discussion we've had today. So just a final critical point, just to reiterate the point again, parties must notify the DPA within 14 days of receiving the note of the meeting as to whether or not they intend to participate in any hearing or indeed inquiry session that we intend to hold, and if so, in which they intend to participate. That just leaves me to thank you all for your input. It's been a long meeting, but it's been extremely helpful from our perspective. We'll look forward to seeing you in June. So thank you very much. Thank you.
Thank you.
Okay.